Hello and welcome to Democracy and Dictatorship. I'm Rohit Gandhi. On today's episode, we're diving deep into the issue of the Uniform Civil Code in India. Article 44 of the Constitution directs the government to have a uniform civil code for its citizens, but it isn't enforceable by law. In countries like India, Afghanistan, Jordan, and many others, what you have are personal laws based on religion. Now the debate about having one civil code has been thrown open. Recently, a Muslim woman appealed in the Supreme Court of India, challenging her divorce by her husband unilaterally, simply by repeating the word talaq or divorce thrice. The government of India has opened a questionnaire asking people to give their opinions and explain their position. Many groups believe it is an interference into their religion. The debate is highly divisive and is primarily skewed against women. Is there a need for the Uniform Civil Code? Our correspondent Dharavi Ved took a look at the challenges of people dealing with issues connected to personal law and the demand for a common code.
In 1985, India's Supreme Court asked a Muslim man to pay his wife a maintenance amount under the alimony provision of Indian law. The husband argued he had paid what was required under the Muslim personal law and was not obliged to pay any further. The court ruled in favor of the woman, but Parliament reversed the verdict under pressure from Islamic orthodoxy. This was the Shah Bano case, a controversial lawsuit that challenged the thin line between religious laws and the Indian legal system. The case inspired a debate over the need for a uniform civil code or a common law. Personal laws in India were first framed during the British rule. The demand for a uniform civil code was first put forward by women activists in India in the 20th century. Currently, laws relating to marriage, divorce, inheritance, and adoption are codified in 14 different enactments for different religions. The Hindu Marriage Act, the Hindu Succession Act, and the Hindu Adoption and Maintenance Act have special provisions for Hindus, Sikhs, Buddhists, and Jains. Marriage in Islam is governed by the Hadith. Inheritance, adoption, divorce, and maintenance are as per the Sharia. Christian marriages come under the Indian Christian Marriage Act, while other personal laws relating to divorce and succession come under the Indian Divorce Act and the Indian Succession Act. For Zoroastrians, marriage and divorce are listed under the Parsi Marriage and Divorce Act, and inheritance comes under the Indian Succession Act. But why a uniform civil code? The argument has been that a secular republic needs a common law for all citizens, rather than differentiated rules based on religion and customs. Also, the rights of women are usually limited under religious law, be it Hindu or Muslim. The practice of triple talaq is a classic example. Reformers like Dr. B.R. Ambedkar fought hard for the passage of the Hindu Code Bill because they saw it as an opportunity to empower women. Muslim social reformer Hamid Dalwai also made the rights of women a central part of his campaign for a uniform civil code. Most Western countries allow religious freedom without the need for a separate personal law. In Christian majority countries, there's a clear separation of the church and the state. France has what is often referred to as a militant version of secularism. The separation of religion and state in France is so complete that the minority Muslim population struggles to express their faith publicly. Countries like Pakistan, Afghanistan, Iran, Iraq, Saudi Arabia, and Yemen are governed strictly by the Sharia. The Uniform Civil Code argued that India, being a secular republic, constitutionally requires the minorities to practice their rights and their religious customs. However, more than just being about the rights of minorities, the Uniform Civil Code is about gender equality, something that has been overlooked in almost every religious custom. Dharavi Ved in New Delhi for WION.
One of the arguments in favor of the Uniform Civil Code is the notion of one people, one law. In theory, it appears to be a rather liberal argument that one appeals to the principle of equality. Yet, there is a sizable number of Indians who oppose the concept of the Common Civil Code, but many stand behind it. In the next report, our correspondent Manoj Keval Ramani explains that divide.
It is an idea that dates back to the founding of the modern Indian state. Yet for nearly 70 years, the Uniform Civil Code has remained elusive. Conventionally, the debate has been waged from the point of view of the persistence of religious conservatism and patriarchy. However, there is another prism to this. In principle, the concept of a common law to replace the multiple personal laws that govern the lives of Indians appears to be a liberal one. It appeals to the notion of equality under law. However, thinkers like Alok Prasanna Kumar say there is far more clarity needed on what uniformity implies.
In the context of the Uniform Civil Code, unless it is clarified what uniformity means, it is not possible to say that this is necessarily a good thing. It is possible that uniformity can also mean gender inequality, it can also mean discrimination on the basis of religion, if it is not clarified as to what uniformity exactly means. In the absence of such clarity, it is not possible to support a notion of a uniform civil code that is only a slogan.
Beyond that, liberal scholars also question whether the notion of uniformity is even desirable or tenable in the Indian context. For instance, writing for WION, Professor Baran Farooqi argues that the Indian constitution negates the principle of one constitution, one personal law. This is good for cultural diversity and the principle of pluralism, of which India has always had reason to be proud of. It is a perspective that is echoed by Mr. Kumar, who believes reform of regressive aspects of personal laws must come from within the communities themselves.
In the context of a federal country like India, when personal laws and family laws have also been given to the state governments, it means that state governments can customize, fine-tune and make better personal laws than what the central government wants to. This means that the constitution itself has a very different idea of uniformity than one nation, one law.
However, it is not that liberal thinkers across India are united in their opposition to the Uniform Civil Code. For instance, in a recent article calling on liberals to get behind the idea, noted historian Ramchandra Guha argues, "In my opinion, left-wing intellectuals who oppose a common civil code disavow the progressive heritage of socialist and feminist movements in India. Others, meanwhile, see no dichotomy between opposing the Uniform Civil Code while seeking personal law reform." Liberal scholars who stand against the notion of a uniform civil code want the government to seek personal law reform by empowering progressive groups within communities. For them, the idea of an overarching law is a non-starter, particularly given that there are no clear principles laid down to explain what such a law would entail. Perhaps doing that could be the starting point for a genuine and substantive debate on the Uniform Civil Code. In New Delhi, this is Manoj Keval Ramani, WION.
Let's take a short break now. When we return, we're going to talk about why people in India need or don't need a uniform civil code. How does lack of that one code create confusion in implementation of gender justice? And why some may still want laws for themselves based on their religion and customs. Welcome back to the show. We have with us in studio Madhu Kishwar. She's a national professor at the Indian Council for Social Science Research. And also joining us is Rohit Dey. He's a lawyer, historian. Thank you both for joining us. Now, even when we begin talking about this debate of the Uniform Civil Code, do you think it's time to begin even talking about it? We are far away from it, right?
No, we're not far away from it because the Constitution put it in directive principles. And every now and then the debate has risen, just that positions have hardened. I, for the life of me, can't understand why at the time of reforming Hindu laws in 1950s, there was a very strong demand even at that time in Parliament that why be selective about it. And Nehru, with his secular principles and all, chose not to go the full length.
Rohit, you have a legal background and now you delve into history. You're a professor of history. Explain to us this journey of having different laws for different religions, especially personal law, which really is invasive when you talk about other communities. It can really create a lot of ruckus.
So if I can just make a short respond to your first question as well. I feel the problem is that the Uniform Civil Code debate is stuck in the 1980s. Both laws have changed, and as Madhu was mentioning, politics within communities have also changed. So how did we end up with the system of personal laws? It's inheritance of almost every country that has had British rule. Part of their system of indirect rule was they wanted to interfere to the extent that they needed to get revenue and maintain law and order. And they had this notion that they will not interfere with the private life of individuals. So whether we look at South Africa, Israel, Malaysia, they all have these systems of laws in place. The reason, and through the period of independence, the first element of nationalist struggle was to resist any kind of encroachment into personal laws. So if we look at sort of the early writings of people like Bankim, there was a lot of criticism of the colonial state trying to intervene in internal mechanisms. By the 1930s and 40s, not only was there a strong sort of Indian women's movement arguing for reform, many of the modernist leaders, including particularly Ambedkar, were asking for a lot of these old laws to be swept away and replaced with something new. And we had codification that to some extent, both of Muslim law in the 1930s and of Hindu law in the 1950s. But somewhere in this, and as you mentioned, this question of conflict is a notion that uniformity is a solution. Uniformity will bring about equality. There is no correlation between that. One can have a uniform law which is very unequal, as one can see with the Hindu law reforms of the 1950s.
So Madhu, what is the fear from your perspective within the minorities? Will this interfere in their personal lives? What's going to happen?
Shahbano Babal, the Bavander
sure, 1985.
That's
sure.
right, 85. I had argued that it's easy to break the stalemate. It's not that difficult. If you acknowledge that on the ground, whether it's Hindu community or it's the Sikhs or the Muslims, each one of them are actually practicing, despite the Hindu law being on the statute book and having made certain provisions, some good, some stupid, some actually idiotic, and now many of them very draconian, like the anti-dowry law, the domestic violence law. It's made mincemeat out of our family laws. Now, what I'd argue is that what continues to operate on the ground is customary practices. For example, communities that practice bride price still continue to do so. Communities that practice dowry, no matter what the law says, the law is invoked only when there's a dispute between the groom's family. The courts of a secular country ought not to be enforcing either Hindu personal law or Muslim personal law or Christian personal law. Sure. The courts should have an egalitarian civil code, which is those who are happy with their personal laws should have the freedom to continue with it. But if somebody feels justice is not being done to them under their community practices, customary laws, or whether they think it's God ordained, then have the option to knock at the courts. So if you give the option, it's not compulsory, you will have an egalitarian code access inequality, equally applicable to all once you approach the courts.
So
there Hindu, Muslim doesn't matter.
That Madhu is referring to actually exists. We actually have something like Uniform Civil Code, but there are several barriers to accessing it. So if you get married under the Special Marriage Act, interestingly, unlike Hindu marriage, it actually requires both of you to expressly say, I give consent to the marriage. There's no Kanyadan. But getting married under the Special Marriage Act is incredibly difficult. You have to put in a 30 days notice. That means a letter goes to the girl's father saying your daughter is getting married. Your pictures are put up in court. So couples who want to get married without the family permission find it easier to get married under Hindu law or Muslim law than to get married under the Special Marriage Act. So if governments are serious really of providing at least this option, they should be looking to strengthening this mechanism and removing many of the barriers in its implementation. No,
I think there is a slight difference in the Civil Marriage Act, or people opting for it, do so under two circumstances. One, runaway marriages, when families are not consenting. Second, when they need a passport and a visa to go to Canada or whatever and take their spouse.
Right.
Then marriage registration is necessary. To my mind, while registration of marriages must be made compulsory, no matter what rituals you followed at the time of marriage, if when the marriage is breaking up, you are not satisfied, you don't get a decent settlement from your community, then either man or the woman, either party, should have the right to go to court and say, my customary law is not giving me justice.
Sure.
And both, not just women, even men.
You know, you talked about the Special Marriage Act, and you know, these acts which keep providing hurdles of actually delivering justice, and people interacting, giving 30 days notice, all of these issues. Let's take a quick break. On the other side of the break, let's come and talk back about how the present law is skewed against women, and that is one of the issues, and some of it, I'm not saying all of it, like you mentioned, there are some laws which are skewed against men as well. When we return, let's continue talking about this. Welcome back to Democracy and Dictatorship. We've been trying to untangle this web around the Uniform Civil Code with Madhu Kishwar and Rohit Dey. Now, let's talk about how a Uniform Civil Code may actually possibly help women against who the present laws may be a bit skewed.
I think one has to interrogate this idea that uniform civil code will necessarily help women. What one has to recognize is that all our personal laws the family laws are skewed against women. However, there's been considerable change since the 1980s. We all keep getting stuck in this Shabano moment, but there was a judgment of the Supreme Court in 2001 in Daniel Latifi case, which actually read the regressive law that was passed to give Muslim women much greater rights to maintenance than women from other communities. What was unfortunate is the judgment has not been popularized and awareness hasn't been created. The real hurdle is not just changing laws, but creating awareness and providing women with resources to ask for redress under the system of laws. Madhu pointed out that some laws are skewed towards men and shifting the burden of proof, but our constitution does allow us to make laws that favor women, children, and members of backward communities, recognizing systemic discrimination over centuries that these groups face. So these laws, while might seem to be unfair on the face of it, are constitutional and follow the tests of the constitution.
So there may be a faulty constitution in itself which allows for you to create laws. You know, we've seen tremendous cases.
There was a considerable debate about it at the time of independence, and part of this was done in recognition that it is hard that if there's it's hard for women to bring cases to court to make these claims. There are a number of cases that are filed in terms of false complaints, whether we look at assault, battery, but whenever we talk about false cases, we fixate about this one particular issue of women going to court and making false claims against men, partly because it's one of those laws that do make people like me and you somewhat insecure because it's something that can be used against us.
70 years ago, it was a different scenario, but today I've personally seen tremendous cases against men sometimes, which are not completely accurate, but at the same time, the Constitution provided for it.
I think, Rohit, you too are stuck in the rhetoric of 1970s and 80s. We've outgrown that. When you introduce into family laws provisions that are more draconian than you want even in TADA, laws dealing with terrorism, laws dealing with serious, heinous crimes, including murder, where a mere allegation is enough to get a whole family locked. So the battle is not, when we talk of family laws, let's not forget, women come in many avatars, not just as young brides. What we've done with our laws is they're excessively and obsessively focused on rights of young brides.
That's not true.
And the assumption
since the last 5 or 6 years, the Domestic Violence Act protects all women inside the household.
Please, just let me finish. But the rights of a mother, a grandmother, a sister, a divorced daughter of the house are not so well protected, and false claims are not just against men. Safeguards need to be built. False cases, if you do, there should be actual punitive measures. And most important, if you don't reform your judicial system, you don't reform your police, which is the most lawless agencies that we can think of, then no matter what kind of laws you make,
so I think what Madhu shows is that there's actually a lot of scope for reform that we can do before even touching many of the family laws.
Sure.
Whether it's sensitizing judges, providing for better police services, or the laws such as the Domestic Violence Act, which isn't classified as a personal law, but actually addresses questions within families.
Or it can happen concurrently. You know, you can make changes in multiple systems as you go along.
If the desire is to give redress to women and there is an urgency, one should proceed with what can be done immediately and then let other things happen. If we keep waiting for transformation everywhere, then you're actually holding women's rights hostage to a certain perceived notion of uniformity.
So let's talk about the concept. If a law is proposed, a uniform civil code is proposed, will there be tremendous opposition from different groups?
It depends on what is being proposed and the process through which this has come about. But we are not stuck in the 1980s. The Supreme Court, for example, has many times pronounced on personal law matters, including involving Muslims, both before the Shah Bano case and after the Shah Bano case, and that's not led to protests. So it's really about a political moment and how something is being phrased and put forward. Secondly, in the 80s, the All India Muslim Personal Law Board did have a wide consensus amongst the community, but there are divergent voices that are emerging now, and I think we must encourage all voices to come about. So groups like the Muslim Mahila Andolan, which is asking for access to the Haji Ali Dargah, taking on the personal law board in many spheres, but also wants Triple Talaq removed, but wants as a solution a uniform code only for Muslims, which works within the framework, keeping certain principles of the Sharia in place. This is how Muslim law reform happened in Pakistan. So polygamy technically is there in Pakistan, but you have to establish for the court that you'll treat all your wives equally, something that is impossible to do. Ending polygamy through law does not remove polygamy as a practice. Under the 2011 National Family Health Survey shows that Hindus and Christians continue to be bigamous, but the only result is that the second wife often doesn't get the rights that she would have got if these marriages were recognized. So one has to be more creative about thinking about solutions without saying the solution is uniformity, one size fits all, and let's sort of put it on top of everybody.
If polygamy was supposed to be allowed, then it should be allowed on both sides to everybody. And why should it not be allowed to everybody? Or if you've decided that we are a monogamous system, we are a monogamous world, then it should be for everybody.
If you believe in free choice, one should allow people to decide whichever kind of relationship they want to get into and have a civil law system in place that lets you, that functions independently and lets you have the
Madhu wants to respond to that.
You know, this free individual, it comes at such partisan moments. For example, while live-in relationships have been made, have been given legal sanctity in the new laws that have come, both in the Domestic Violence Act as well as in the new divorce laws, that the live-in partner, never mind if she's been living only for 6 months, can claim the same rights to matrimonial home, as somebody, a wife who's put her life for 30 years into a marriage. I find that atrocious. On the other hand, this whole business of Maitri Karar in Gujarat, where live-in relationships are contractual, the two sides enter into a contract, that they want banned. You say ban Khap Panchayat, but would you say ban Muslim Personal Law Board? No, you wouldn't dare do that. I'm saying just don't be selective in your outrage, don't be selective in your definition of freedom. Same, what's good for goose is good for gander. And that's why I propose that the law, the egalitarian code that the court should provide be made optional. Yeah. If you are happy with the existing customs of your community, and why should Kerala's matrilineal community women not prefer their personal law to what the Hindu Succession Act gives them? Why not let them have it? If Muslim women are okay with polygamy, so be it. Because unless the person wishes to avail of the benefits that the state provided laws bring, let them be, you know.
So when we talk about uniform civil code, we're talking about a legal system. If somebody does not want to be part of that legal system, hallelujah, go your way, right? But if one of the parties affected wants to approach the legal system, then there is one.
We have that. It's called the Special Marriage Act. It's
no, it's not the same thing.
No, it is unfortunately only used for people doing interreligious marriage, but there's nothing preventing two Hindus or two Muslims to get married under Special Marriage Act.
So will a uniform civil code then help people with multiple religions to even get married.
The Special Marriage Act presumably does that. You can go there if you're from two
But it's
different faiths.
prohibited.
And get
No,
married. No, it's
no,
not.
no.
Under Special Marriage Act, people of two different faiths. In fact, it was done.
It's prohibited.
primarily-
You yourself said 30 days waiting
It is difficult,
period.
so one should remove the
That's not
requirement.
the
One
issue,
should make it easier.
Rohit.
Yeah.
That's not the issue. The issue is, even if you married with Saat Peras, even if you married according to your religious rites in a mosque or in a mandir, you should be, if you approach the secular courts of India, you should then get secular law. Why should I get Hindu personal law when I go to a secular court? If I want Hindu
Absolutely.
personal law, let me go to my Jat Biradari, let me go to the local Maulvi, let me go to the Granthi in the Gurdwara. Sorry, secular courts have no business to be educating the religious laws of any community. That's my bottom line.
Thank you, Madhu. Thank you, Rohit. On the one hand, there is ambiguity over what a uniform law would look like for a country as diverse as India. On the other, we must account for the misuse of personal laws over the years. And countries across the globe seem to have many. What we do know is that people's basic human rights should not be violated. But what we are far from reaching is a consensus on the issue, because nothing is absolute.